Did you know that a criminal record creates long term obstacles? And yes, you do have the right to seek a pardon by obtaining a record suspension that helps you clear standard background checks to access life changing opportunities. Why is this so important? Here is the law. You have a criminal record. It's holding you back from jobs, housing, and even travel. Every time you fill out an application form, you dread the question, have you ever been convicted of a crime? Here is the good news. You can get a pardon and start afresh. In Canada, a pardon is now called a record suspension, and it can remove your criminal record from the Canadian Police Information Center database. So most employers, landlords, and volunteer organizations wouldn't see it. Today, we are going to walk you through exactly how to apply without a lawyer and give you a step-by-step guide to clearing your record. So let's start. What is a record suspension? A record suspension, formerly called pardon, is an order from the Parole Board of Canada that sets your criminal record aside in the Canadian Police Information Center database. This means that a routine background check will now show your conviction. It does not erase the fact that you were convicted. So let's get that straight. But it keeps the record separate and apart from other records. A record suspension can help you access employment opportunities, housing. Landlords may not know about your record. Education, application for schools and scholarships may not require disclosure. Volunteer opportunities you can give back to your community. So all of this is a solid reason why you may want to get a record suspension. Important note, a record suspension does not guarantee entry or a visa to another country. So before you travel, contact the authorities of any country you wish to visit and ensure that you understand what their regulations and requirements are. And sexual offenses continue to be flagged in vulnerable sector checks. Now, are you eligible to apply for record suspension? Before you start the application process, you need to confirm that you're eligible. You may apply if you were convicted of an offense in Canada under a federal act or regulation as an adult. If you were convicted of a crime in another country and transferred to Canada under the Transfer of Offenders Act, you do not need to apply if you have received an absolute or conditional discharge. Or if you are only convicted in a youth court, your youth records will be destroyed or archived once applicable time has elapsed. Now, you may not be eligible if your first offense was committed on or after March 13th, 2012, and you have been convicted of more than 3 indictable offenses with a prison term of 2 years or more for each. Equally, you are not eligible and you shouldn't apply if you are convicted of a Schedule 1 offense, sexual offense involving a child, under the Criminal Records Act. Now, let's talk about the waiting period. Once you've completed all of your sentences, you must wait for 5 years for a summary offense and 10 years for an indictable offense. The waiting period begins after you have paid all fines, surcharges, costs, and restitution in full, completed all sentence of imprisonment, including parole and statutory release, completed any probation orders. So just make sure you understand your eligibility and when it's absolutely futile to apply. Important. If you were ordered to pay a fine or restitution as part of your sentence, the waiting period only starts once you've paid in full. Proof of payment must be provided with your application. Okay, now let's go step by step with the application guide. Now, the first thing you need to know is that the Parole Board of Canada has made it clear you do not need a lawyer or a representative to apply. In fact, using a for-profit third-party company would not guarantee a record suspension or fast-track your application or give it any special status. So, if you have the capacity and you have the ability to do it, you may just want to proceed on your own. Here's your guide to do so. Step 1, confirm your eligibility. Visit the Parole Board of Canada's website and use their Am I eligible link online and check and see if you are qualified. Step 2, get your fingerprint. You must obtain a certified copy of your criminal record from the RCMP. This is done by submitting your fingerprints to an accredited fingerprinting company or police service. The RCMP will provide you with a certified copy of your criminal record for this purpose. Step 3, gather your documents. You will need a certified copy of your criminal record, as I mentioned earlier, court documents confirming that all parts of your sentence were completed, proof of payment of all fines, restitution, and surcharges, local police checks from any jurisdiction you have resided in within the last 5 years. Step 5, complete the application forms. Download the official record suspension application guide from the Parole Board of Canada's website. A link is in our bio below. Fill out all forms completely and truthfully. Important to answer all questions truthfully and completely. Hiding information or making false statements could cost you your application. And so it's not worth if you're going to be untrue in your application to even apply. Got it? All right. Step 5, write your personal statement. So this is the point where you will need to write a statement describing how your life has changed since the conviction, why you are seeking the record suspension, how you have stayed out of trouble and demonstrated good conduct. Step 6, submit your application. Mail your completed application package to the Parole Board of Canada with the $50 application processing fee made payable to the Receiver General for Canada. You are also responsible for any additional fees getting your fingerprints, criminal record, court documents, and police checks. Step 7, wait for the decision. Once your application is accepted as complete and eligible, processing times vary. Summary offenses, for example, processed within 6 months of application acceptance. Indictable offenses processed within 12 months of acceptance. Complex cases where the board is proposing to refuse may take up to 24 months after acceptance. Step 8. If granted, your record is set aside. If the parole board grants your record suspension, your criminal record will be set aside in the CPIC database and will not show up in most background checks. Step 9. This is important. Maintain good conduct. A record suspension can be revoked if you are convicted of a new indictable offense, or equally are found to no longer be of good conduct, or made a false or misleading statement in your application. So, in summary, here's the law and here's your move. Your criminal record doesn't have to define your future. A record suspension opens doors to employment, housing, and education. You can do this yourself. The Parole Board of Canada has made the process accessible. You don't need a lawyer, and you don't need to pay thousands of dollars to a third-party company. So, visit the Parole Board of Canada's website, download the application guide, start your application today. This is Ichatlaw, where the law gets real. If you found this helpful, please like, subscribe, and turn on your post notifications. We post every weekday, Monday to Friday. And now you know.